Check out this video for a summary of everything I covered, sourced from CoinMarketCap. Don't forget to subscribe to my channel for more updates on XRP and other cryptocurrencies. Before a crucial pre-trial session, regulatory uncertainty is highlighted by the settlement talks between Ripple and SEC. In an important move when leveraging social media platforms, Ripple Labs and the U.S. Securities and Exchange Commission announced on March 29th that they would begin settlement talks to end ongoing disputes before a critical pre-trial hearing scheduled for April. The chief legal officer of Ripple, Stuart Elliott-Rowe, expressed his displeasure with the Securities and Exchange Commission's second misstep in offering precise regulatory guidance to the cryptocurrency industry. Aldera used 8 notable cryptocurrency lawsuits to demonstrate the regulatory issues that are now impacting the IND in order to highlight the ambiguity in his rejection of the SEC. In order to address their differences, the court ordered Ripple Labs and the Securities and Exchange Commission to engage in settlement discussions. In order to address these issues ahead of the final pre-trial conference that Judge Analisa Torres has scheduled for April 16th, a settlement session was held in Manhattan with attendance from Ripple CEO Brad Garlinghouse and Alder. As a result of this meeting, the significance of negotiating a potential settlement was brought to light, highlighting one of the extreme positions taken by the Securities and Exchange Commission California. Intends to take Ripple Labs to court for a final ruling. Furthermore, the CC is seeking nearly $2 billion in civil fines, permanent injunctions, and deterrence with prejudgment interest. The leadership of Ripple, particularly Garlinghouse and Alder, has responded angrily to this strategy, stating that in a planned filing set for April 22nd, they want to contest what they view as the SEC's regulatory overreach. The cryptocurrency community is closely monitoring this case because the verdict in the Coinbase v. CCC lawsuit, which disagreed with Judge Torres's reasoning in the Ripple case, could have a significant impact on how digital assets are regulated in the United States. In the midst of these legal challenges, pro-XRP attorney Bill Morgan addressed the concerns of the XRP community, particularly about the implications of XRP secondary sales. Morgan brought attention to the comments made by Judge Torres regarding the insufficient consideration given by the CCQ to the distinction between secondary and program sales. This distinction is an important aspect of Ripple's case and a bipartisan one. The case, specifically about secondary market sales, has been the subject of intense dispute regarding the SEC's regulatory approach and transparency because of this disparity. AOS and lawyers have been debating whether or not secondary transactions could be considered investment contracts. In anticipation of the pre-trial session on April 16th, both sides are preparing for a showdown that could have a significant impact on the future of Bitcoin legislation and enforcement in the jurisdiction. Over the last 5 hours, the price of XRP has dropped from a high of 0.6 to a level that is lower than 61 cents. The ongoing legal battle between Ripple and the Securities and Exchange Commission is continuing to captivate the cryptocurrency sector.